If you are a Commonwealth of Pennsylvania resident and a medical cannabis user, this episode is for you. My name is Emily Sisneros, the founder and CEO of Canna Business Services, and we've got a video you won't want to miss if you are an employer or employee in the state and medical cannabis is an issue for you. There was a recent federal court case involving a plaintiff, the person bringing the case, who argued that he was offered a job and that job was rescinded because of his medical cannabis use. And he was claiming two things. One, he was discriminated against based on a disability under the Pennsylvania Human Relations Act, the PHRA. And the other claim he brought was under the Medical Marijuana Act, which is the MMA. Under this act, he argued that the employer was not allowed to rescind a job offer because he was part of the medical cannabis program. This is important because it shows a fracture in current state law where there is existing employment law issues that employers have to abide by when they're hiring employees, and employees have to consider when they're looking for a job. And then you've got a medical cannabis program that is providing broader protections for employees who participate in the program. And in this case, the federal district judge agreed. This case went through the Commonwealth Court and into the federal court, and this is where the judge ruled that the first claim should be dismissed. And I do agree with him here. The first claim, meaning the Pennsylvania Human Relations Act claim, the one arguing discrimination for his disability, should be dismissed because he was arguing that his participation in the program falls under that act and the protections afforded by that act. But there's nothing in the act that qualifies him to have a disability as a medical cannabis user. So I agree with the judge here that this claim should be dismissed. Now, I also agree with the judge that the second claim, the claim under the Medical Marijuana Act, should move forward. And that is exactly what the judge did because he believes that the MMA offers broader protections for employees because it states that an employer cannot discriminate against an employee by not hiring them or rescinding a job offer or firing them solely for their medical cannabis use and participation in the medical cannabis program. So why does this matter for you? If you're an employer, this means you really need to have a thorough understanding of the ever-changing rules and regulations that apply to you as a business owner. This directly affects your training, your hiring, your drug screening process, all kinds of things. So make sure you get with a lawyer who is fluent in the cannabis industry and also employment law. If you do not have an employer that is qualified in both of those aspects, feel free to reach out to us and we can recommend our vetted and pre-screened attorneys that we would recommend for you. You can reach out to us at info@cannabusinessservices.com. If you're an employee and you're using medical cannabis, this is a really important ruling for you. This shows that the state is on a trajectory of understanding the MMA and its usefulness for employees who are participating in a legal medical program. Now, to be clear, if you are looking for a job and you are taking a drug screening test and you pop on that drug test because you use cannabis, but you are not part of the state's medical cannabis program, none of this applies to you. So make sure you are qualified by abiding by the state's rules and participating in the medical cannabis program. And if you're uncomfortable participating in the program, putting your name in a state registry, then you'll have to wait until the state ultimately legalizes adult use cannabis for those aged 21 and older. When that happens, you won't need to put your name in a state registry. I know a lot of people in the Commonwealth are really fearful of that, and maybe rightfully so, right? I wouldn't want my name and information in a database, especially when it conflicts with firearm ownership and the forms that you have to fill out there. That's a topic for another day, and I think we actually have a couple videos of that on our YouTube page, which you can find at Canna Business Services on YouTube. But if you are a participant in the current program, these are the types of rules that will apply for you. If you don't participate currently, you may have to wait until the adult use program if you are uncomfortable participating in the medical cannabis program, or you have to refrain from using cannabis at all so that you don't pop on a drug test because you are not afforded the protections of the MMA if you are not a legal participant in the program. We will continue monitoring this case as it continues through the courts. That's the update from March. So as this case progresses, it will certainly give us all new insights on how the courts will rule in favor of employees and employers in these types of matters. So stay tuned, subscribe to our YouTube channel, Canna Business Services. Check out our website at www.cannabusinessservices.com or shoot us an email at info@cannabusinessservices.com.